Hey, welcome to Lunchtime Law. I hope you had a wonderful 4th of July holiday weekend. I'll tell you, I thought the fireworks were amazing this year in the celebration of the 250th. And Boston had the coolest drone show too, which showed a history of Boston from the Revolutionary War and Paul Revere's ride. I was going to play some of that for you today, and I didn't get a chance to put it all together. So I'll do that at the end of the show tomorrow. If you're new here, I'm Margaret McLean, your host. I'm a former prosecutor, civil trial lawyer, and of course, law professor. And this is where we take the legal stories that I would say are dominating the headlines and translate what is really actually happening inside police investigations and the courtroom. Today, I'm serving up two big cases for you. First, the kidnapping of Nancy Guthrie. I can't believe it's been 5 months after the 84-year-old mother of today's show host, Savannah Guthrie, who I have to say we all love. She disappeared from her Arizona home, and I'd say investigators are still trying to answer two critical questions, and that would be who on earth left those first two ransom notes, and why those in particular? Then we're going inside the trial, Blaise Taylor, the former college football star and Tennessee Titans scout. So, how did prosecutors build a circumstantial case against him? Why were there 4M convictions, yet only 2 victims? So, ponder that one for a minute. So, today we're going to talk about, I'll tell you everything from fake ransom demands, Bitcoin, circumstantial evidence, fetal homicide laws, and why prosecutors sometimes charge multiple M accounts for the same deaths. So we've got a lot on our plate today. I'm excited that you guys are joining me. So let's first start with Nancy Guthrie. I'm going to put a picture of her up today, which of course we've all seen. And let's see, here she is. Here's Savannah and of course Nancy in better days. So 5 months after Nancy was kidnapped from her Arizona home in the middle of the night, right? Investigators continue to examine multiple ransom demands connected to her disappearance. And the FBI has essentially divided these communications into categories. Some have been deemed illegitimate extortion attempts. Those are the callous schemers, the bad guys looking to profit from a family's desperation. I mean, it's just awful when they do that, but they do. For example, an initial anonymous law enforcement leak, this is interesting, to Reuters stated that all communications were bogus, all of them. However, that's not necessarily true. So I would say a major red flag for investigators early on was that a small amount of cryptocurrency deposited into the initial Bitcoin address went untouched, completely untouched. And criminologists also noted a total lack of proof of life or proof of death in the letters, suggesting the senders were using publicly available information that we all know about in an attempt to extort money. However, other ransom demands may be legitimate and remain under investigation. These appear to be the ones that were early on that investigators have reportedly treated as potentially significant. In fact, the FBI Phoenix headquarters explicitly pushed back against reports that all notes were fake. So the earliest notes sent to the local Tucson stations and TMZ days after Nancy was taken contained specific non-public details. So here's the question. How does the FBI determine which ransom demands are real? First, they have to authenticate the communication, and they would be looking at questions like, Does the sender know something that was never released publicly? Do they know details about the abduction? Can they describe something specific about Nancy that wasn't released? Or can they identify something inside the home? Can they provide legitimate proof of life? And can the FBI, of course, trace the communication or follow the money trail? And in this case, we're talking about ransom demands involving Bitcoin. And I'll tell you, today, investigators it's tough, right? They're tracking cryptocurrency transactions, digital wallets, metadata, electronic communications, IP information, and all sorts of in devices, right? And then there's AI, which presents another big challenge, not just for the college student trying to get jobs, but in investigations. For example, it's getting better and better. So if someone sends investigators a photograph claiming to show Nancy at some point, they have to decide, is that photograph real? Images are so easy to manipulate these days. And I haven't really figured out how to do that and make myself younger, but it's okay. There's still a lot for investigators to sift through, and that's really the bottom line. So let's see. Another thing with this is that I think is interesting is the initial ransom demanded by the somebody out there. They sought $4 million in Bitcoin and threatened to raise the amount to 6 million. Did I say billion? I meant 4 million. And raise the amount to 6 million before a subsequent note claimed she had actually died. Nancy had died. Now, a third, more recent note sent to TMZ claimed to reveal the identities of the kidnappers, but the Pima County Sheriff and experts out there, especially from the FBI, dismissed that as illegitimate. The early ransom demands included accurate descriptions of Nancy Guthrie's attire on the night she vanished. So that's a big one. And this is interesting too. They noted a broken floodlight on her back porch. And I think the biggest clue of all, this information recently came out, is that her white banded Apple Watch was lying on the floor next to her bed. So because of these insider details, right, both the FBI and the Guthrie family continue to treat those early demands seriously. They think those perhaps are legitimate. Now, before we get next, I'm going to be talking about the famous Lindbergh baby kidnapping and what the parallels are with Nancy Guthrie's case. But first, I want to play you a clip where I previously interviewed Jennifer Coffendaffer, who's most people know who she is. She's ex-FBI, and she has done a lot of work on the Nancy Guthrie case. She talks about it just about every day. So I interviewed her, and I want to play a clip where we talk about the earlier demands, which she believes are real as well, and the Bitcoin and whether the FBI can trace Bitcoin transactions. So I'm going to play that right now for you guys. Just give me a chance. And it's right here. So this is the two of us discussing Nancy Guthrie, and it's just about 3 minutes long. And I kind of liked my hair better there, but this time I have it up. All right, here we go. What do you make of the two letters from that TMZ received? Those two, I would call them demand letters recently.
Yeah, it's interesting. Of course, they fall right in line with the previous letters sent by the same person. And the reason they know it's the same person, meaning the last or the set of letters that started or emails that started on February 11th, as opposed to the ones that were prior to that, which are the two that they're saying are related to the abductors, at least that they believe are related to the abductors. So now you just have it continuing, right? This individual saying, listen, I know who did this. I know where she is. I shouldn't say buried, but where she is, blah, blah, blah. I want a half a Bitcoin now. He's really dropped his price down.
Yeah.
4,000 is all he wants. And then 34,000 after, they find her and things like that. What I make out of it is this is a person that is torturing this family, and they're horrible. This is all never been about money. Any of these notes are about sheer torture for the family and having their name out in the media and being in control. These people are ruthless.
Oh, I agree. And I thought the timing with these last two letters was right when Savannah was going back on the Today Show.
Yeah, you're right. She went on the Today Show. The letters came out that day.
Yep.
And so if that isn't a message, I don't know what is.
Exactly. And then now let me ask you, do you think TMZ should have gone public with it? Why not just hand them over to the FBI? What's your thought on that?
Well, my FBI hat says, please don't go public, TMZ. Please just hand them over. Absolutely. I mean, that's what you want to see as an investigator. You don't want to see this splashed all over. But look at all of us in the media. We're all talking about it because we see how important it is. I think it's so important because I think they should be acted on. Not everybody agrees with me, but I look at it this way. People think Bitcoin isn't traceable, and that is absolutely could be further from the truth. It is extremely traceable. This is the issue. Even though they trace all the transactions, the person at the other end, they can be anonymous. But once you have a start, once you see how the Bitcoin is then converted to some usable currency, then you have a start, you have a breadcrumb that could possibly lead to who did that. Now, does that mean that's leading to the abductor? Or does that mean that's just leading to a piece of crap, evil person who's been doing this to Savannah and the Guthries for 34?
And again, thanks to Jen Coffendeffer for providing us with that little clip there talking about Bitcoin. I think it's very interesting. So of course, I thought I'd put the images up here that we've all seen. This is Porch Guy. We've never figured, the investigators have never figured out who he is. There's speculation, is he still alive? And where is he? So, or was this a one-off where he just got lucky and pulled it off? So there's so many theories out there and speculation, but I'm sure the FBI has kept a lot of it back from the public because they don't want to show their cards. So that brings me next to the Lindbergh case. And I've got a slide on that. That's Mrs. Lindbergh and the baby that was kidnapped. So Lindbergh baby kidnapping was one of the most important or biggest cases in American history. And it did a lot to change the law. The Lindbergh baby kidnapping, it was just quite a media sensation, and many experts actually have compared it to the Nancy Guthrie investigation. There's a lot of parallels that I'm going to go through. I find that interesting, the comparison. So that's why I researched it this weekend. And I really love history too. So you'll see that on my channel, certain parallels in history, or I try to teach, putting my professor hat on, I try to teach a little bit about the Constitution, what the framers intended, and some of the stuff I taught my students at Boston College. So I found that this interesting because the cases happened, of course, nearly a century apart. That the technology is, as we know, is worlds apart. And just a little information, Charles Lindbergh at the time was one of the most famous people in America. And here we have Nancy Guthrie as the mother of Savannah Guthrie, who's also one of the most recognizable faces on morning television. I've been watching her for years. Both crimes involve victims connected to enormous public fame, and both were taken from locations where, they should have been safe. The Lindbergh baby was abducted from the family's New Jersey estate, and Nancy Guthrie was taken from her private residence in the middle of the night. Both cases involved ransom demands. In the Lindbergh case, and let me show you another slide on it. So the next slide is the letter. So I'm gonna make that bigger in a second. But the Lindbergh case here, you have the initial demand was $50,000. Let me take me off for a second. And this was it. It said, "Dear sir, have 50,000 ready, 25,000 in $20 bills, 15,000 in $10 bills," and that's a lot. And what's that? 10,000 in $5 bills. "After 2 to 4 days, we will inform you where to deliver the money. We warn you for making anything public or for notify the police, the child in gut care." God knows what that means. "Indication for all letters are signature and 3 holes." So whoever wrote the letters did not speak English very well. And here is the handwriting. So ultimately, they did use that they used handwriting experts back then. So I thought that was interesting, and put me back on here. There I am. So going on, the Guthrie case, of course, the ransom was not in dollars and $5 bills, $20 bills, but of course, we know it was in Bitcoin. And of course, both cases became national obsessions. The Lindbergh kidnapping helped create what we now recognize as the modern media circus surrounding a criminal case. It wasn't OJ, it was well before OJ that we had big circuses. So newspapers back in the day were big, and they competed for breaking developments. The public obsessively talked about clues and, of course, conspiracy theories. Amateur detectives inserted themselves into the investigation. And I'm asking you, does that sound familiar? Of course it does. Now we have people dissecting ransom notes and debating suspects in real time. In the Nancy Guthrie case, people still think Nancy's daughter and son-in-law may have been involved because Tommaso was the last person to see her alive. Other than Porch Guy, right? Here's an interesting fact also going back to the Lindbergh case, and I didn't know this one. Approximately 200 people confessed to kidnapping the Lindbergh baby. So obviously 200 people didn't kidnap one child. So I'm going to go off on a little bit of a tangent here. Why would an innocent person confess to a crime that they didn't commit, right? So I did a little research on that too and came up with this. The American Psychological Association has studied false confessions extensively. A confession that may be legally considered voluntary and therefore potentially admissible in court into evidence does not conclusively establish actual guilt. So a voluntary confession is not necessarily a true confession. And there are times when confessions are improperly coerced by the police, and that those are not considered voluntary. But what I'm talking about is different. When people actually come in and say, "I did it," right? So psychologists have identified several reasons that innocent people may voluntarily confess. Some people have a pathological need for attention or notoriety. Some experience guilt or delusions of involvement. And some believe there may be a tangible benefit somehow to confessing, while others falsely confess to protect someone they love. For example, they're protecting a parent, a child, or a spouse. Sometimes people want to insert themselves into a famous crime, and we've seen that a lot. And I'd say that the Lindbergh kidnapping is a big example of that. I mean, I can't imagine 200 people confessing. Imagine if you were the investigators back then having to sift through all of that. And we have seen this phenomenon in more recent high-profile cases. For example, just one that I came up with in 2006. John Mark Carr voluntarily claimed responsibility for the murder of John Benet Ramsey. The claim generated enormous international attention, but the evidence did not support his confession. So sometimes prosecutors get involved, and I did get involved in certain types of cases. And I'll tell you, though, those confessions have to be tested. And the way we do that is, does the person uh, who is confessing know information that was never released to the public? Can they describe something about the crime scene that, of course, wasn't released in the newspapers or online? Does the timeline work? Does the forensic evidence support the story? Can investigators independently corroborate the statement? Don't get me wrong, a confession is evidence, sometimes incredibly powerful evidence, but a confession is not automatically the truth here. Now, that brings me back to Nancy Guthrie. All right. Let me look at my slideshow here for a second. Let me take this. Oh, this is the note. I had more on Lindbergh, and we'll get to that. That's, of course, one of the early wanted posters. Okay, I'm going to show this comment. So sometimes I've got to put my glasses on to read the comments. I'm a little bit slow at that, but I will be getting better, I promise you. So this one is interesting from Lou Lamaraco. I hope I'm pronouncing that right, Lou. With your experience, Margaret, can you tell us the challenges the prosecution will have when it goes to trial, the many mistakes made from the very beginning, and what to expect at this trial? And Lou, I'm assuming you're talking about if the Nancy Guthrie case went to trial. So yes, I've actually will be talking about that. So in this section, I'm waiting a little bit to after the Lindbergh case to talk about some of the challenges. And I'm also going to be talking about circumstantial evidence, because in the Nancy Guthrie case, it appears to me it's similar to Lindbergh, and I'll explain why, because it will ultimately be a very circumstantial case. The prosecutors will have to sell to the jury, but they can do it. I've done it. Sometimes it works, sometimes it doesn't. Okay, so back to thank you for the comment. I appreciated them, because I'm here to teach you guys. So the FBI says it's received multiple ransom demands on Nancy. Some have been deemed illegitimate. We talked about that. Others remain under investigation, and it's still the same fundamental investigative problem if you go back to 1932, right? Investigators have to decide who is telling the truth. So in 1932, investigators dealt with people falsely confessing to kidnapping in the Lindbergh case. Today, someone can send a ransom demand electronically demanding Bitcoin and insert themselves into a major federal investigation without ever leaving their home. So it's much easier to do today. The technology has changed. Human behavior, though, has not changed. Really high-profile crimes attract people who are seeking notoriety. And public obsession, of course, as we know, creates noise. And just look at the Karen Reed case. So the FBI has to identify the real ransom note communication containing information only the kidnappers could know. And that demand can be corroborated, and ultimately a digital trail will have to be traced. So that's some of the evidence that would, again, I'm big on timelines. So hopefully this case will ultimately, just break wide open. It could break wide open today, tomorrow, and I hope it does. And I think that what we may need is someone to come forward ultimately. But once it breaks, it's going to break wide open, in my opinion. So going back to a little bit on the comment, how the Lindberghs, as circumstantial as it was, it finally prosecuted back in the day. And hopefully we'll see the parallels, like I said, when the suspect is finally arrested in the Nancy Guthrie case. So the Lindbergh investigation initially struggled, just like Nancy Guthrie is right now. So back then, the ransom money helped lead investigators trace it to Bruno Richard Hauptmann. And was a German immigrant, because he's not here anymore, who was ultimately charged with extortion and first-degree M. He pleaded not guilty, and then his trial began in January of 1935. And of course, it was a media circus at the time. Charles and Anne Morrow Lindbergh. Now, she was famous as well. Both of them were really a big part of New York society back in the day. So they both took the witness stand, and so did John Condon, the ransom intermediary. So he was the middle guy that took the money and then gave it to, allegedly, according to him and his testimony, gave it to the defendant. So he took the stand, and his name was known as Jaffe. So he testified and identified Hauptmann, the defendant, as the man to whom he paid the ransom. But prosecutors also had physical evidence that they used, and they built a circumstantial case. They had a ladder, and a wood scientist took the stand as a forensic expert back in the day. He was able to examine the ladder, allegedly, used in the kidnapping, and concluded that portions of that ladder, which was used, because I actually have, let's see here, I've got a slide showing that ladder. So again, that's, so here, I'm going to take myself off for a second so you guys can see, remove, and here we go. So this is the ladder that was back in the day, and this is actually the police and the investigators. They were reconstructing the crime back in the day, and I'm sure back then they used photography. 1932, I do believe they would have used film, but I'm not sure if that was used at the time. So they also had, like I said, they had the ladder, and the wood expert examined it and told the jurors that the portions of the ladder matched the lumber associated with Hauptmann's attic. So they did a match of the wood back in the day. Of course, they didn't have any DNA evidence. So they had a handwriting expert and the ladder to construct circumstantial evidence connecting the defendant. 3 weeks into the trial, the defendant Hauptmann took the witness stand, which attorneys in these days, and I'm sure back then too, would have advised him not to. He admitted to lying to the police initially, but continued to insist that he was innocent. Ultimately, the jury convicted him, and I've got a picture of him in here too. That's him. Ultimately, the jury convicted him of first-degree M, and he was sentenced to death on April 3rd, 1936. So it happened quicker back in the day. So the trial, remember, was in 1935, but a year later, Bruno Richard Hauptmann was executed in the electric chair at the New Jersey State Prison in Trenton. So he was executed quite quickly. Times have changed. Oh, there I am again. Yes, so I want to put this, hold on, let me put this on. Yes, a lot of people think it could have been an inside job. And I did see that in my research. I didn't have a chance to read any of the books about the case being an inside job. Back then, I think about it, there must have been a rush to judgment. It was such a big case. Can we believe the witnesses who took the stand? But what I would like to do, and I think it would be very interesting, is to get one of those experts that wrote the books on conspiracy theories on the show. I think that would be very, very interesting to kind of compare our conspiracy trials that we watch today. And some of this stuff really does happen where there's such a rush to judgment, And God knows, if those witnesses were reliable. So I would like to actually learn more about that. And I'd like to have a show on that as well. Um, and of course, I like that those move faster, to be honest. Yeah, you know what? That's true. Of course, they're, giving somebody the death penalty, I would say, is so serious. I think that's why the appeals go on and on and on and on. But, that's another discussion that we can have sometime as to whether the appeal process takes too much time these days. Of course, people are divided over whether we should have the death penalty or not. But that back in the day, man, I actually have a friend from Norwell who I have to divert here. This was kind of interesting. Back in the day, there's a big, so if you go in their house, right, it's an antique, and they have this big oil painting of his, I don't know, great grandfather, who was the last hanging judge in Massachusetts. So he must have sentenced the last person who was actually hanged in Massachusetts. So it didn't show him holding a noose, but I just always envisioned the great grandfather holding a noose. But yeah, now I forgot who it was, but the last hanging judge in Massachusetts, kind of eerie. So where was I now? I got to remember where I was. This is big. So one of the things I'd like to get into is how the Lindbergh kidnapping changed American law. This is why the FBI is involved in the Guthrie investigation to begin with. It goes back to this Lindbergh case. So here's a little bit of my law professor hat. Congress passed the Federal Kidnapping Act of 1932, commonly known as the Lindbergh Law. So the federal government now has after the law was passed in 1932, they had a much greater role in kidnapping cases involving interstate transportation, interstate commerce. So a criminal investigation can quickly involve multiple jurisdictions. As we know, very often people are kidnapped over state lines, and the Lindbergh kidnapping exposed the limitations that investigators faced, local investigators, in pursuing a major kidnapping case across jurisdictional lines. So Nancy got nearly a century later, we see the legacy of federal kidnapping law in our modern investigations. And, the federal Nancy Guthrie case is an example. The FBI can bring federal resources, forensic specialists, digital investigators, and interstate investigative authority to a case. And I'm really glad we have that now. Hold on, I'm losing my voice. Yes, it's from the 4th of July. And I got water in my eye. I don't know how I did that. So, like I said, the federal involvement may be critical in the Nancy Guthrie investigation. But another parallel, again, is the public obsession. Nearly a century later, people are still debating that Hauptmann prosecution with all kinds of conspiracy theories. And we have to get somebody on for that. Again, was the eyewitness identification reliable? That was a big one. Was the the wooden ladder evidence as strong as prosecutions claimed it was? I mean, comparing wood like that, I don't know. I find that very interesting. People have all different kinds of woods in their attic. I'd rather see solid DNA evidence. So we'll have to look into that. Also, did investigators focus too quickly on Hauptmann, the defendant? Did the enormous pressure make them focus on him and point their investigation towards him? So those questions, of course, remain part of the historical debate. And now we are watching that Nancy Guthrie investigation in real time as it unfolds. We're looking at algorithms, cryptocurrency, artificial intelligence, and of course, the 24-hour digital speculation. And I'm guilty of that right now. But I'd say different century, different technology, the same haunting question: who did it? Who was responsible, right? So again, they've got to build that circumstantial case. Now, the reason I also wanted to talk about the Blaise, the next case, I've got to, hold on, I've got another slide. But Blaise Taylor was also another case built on circumstantial evidence. So that's kind of what ties all three cases together. And the Blaise Taylor case, the verdict just came down right before the 4th of July weekend. I think on the, correct me if I'm wrong, the 3rd of July. So, oh, this was my slide that I forgot to mention, that how now we have modern FBI technology in the Nancy Guthrie case as a result of the Lindbergh case. So that's the slide I was going to use. So here's Blaise Taylor. And I found this case to be quite interesting, and I wish I had followed it from the get-go, but I was all wrapped up in what was going on in Karen Reed last week. So in this case, I think it actually has an extraordinary factual pattern. This guy was a former college football star, an NFL scout, and he's been convicted of emming, his, I can't say that word, his pregnant girlfriend and their unborn child. So Blaise Taylor was a 4-year starter at Arkansas State, a team captain. I mean, this guy had it going on. He was a first team all Sun Belt as a defensive back, and he was a punt returner. He later spent 4 years working in the Tennessee Titans office scouting department. That's a great job. And he was working as a defensive analyst for the University of Utah when, of course, he was arrested in 2024. So what I found impressive was prosecutors. I mean, this is kind of crazy, but prosecutors say that behind this quite impressive resume on all fronts, right? Football and landing that great job. I do think he had a connection. I believe his father was also famous. But behind it all, there was a calculated plan to eliminate a pregnancy that this guy, Taylor, did not want. And what was the weapon? The weapon was, sadly, believe it or not, pink lemonade. So prosecutors accused Taylor of secretly putting a large amount of cocaine into a drink belonging to his 25-year-old girlfriend, Jade Benning. And I've got her picture here as well. That's her. I find this particular picture so sad. And that's, of course, a slide of her holding her, the pictures of her unborn baby from the ultrasound. So, and then she's eating ice cream. So she did want this pregnancy. On February 25th, when it happened, Taylor called 911. So you've got the ex-football player calling 911. He reported that Jade, his girlfriend, appeared to be suffering from an allergic reaction. Right. She was rushed to the hospital. Her condition quickly became critical. She was unable to tell police what had happened to her before her death. And her unborn daughter, Ivy, died on February 27th. And Jade died on March 6th. And the sad thing about that, it was her 25th birthday. So a Nashville jury has now convicted Blaise Taylor on all counts. And the jury deliberated for only 2 hours. Now, as a former prosecutor, right, when I hear a 2 hours, wow, I immediately ask the question, what evidence made this case so compelling to the jury? There were no eyewitnesses who saw Blaise Taylor put cocaine in Jade's drink. There was no video at all showing the poisoning. So how did prosecutors prove murder beyond a reasonable doubt, right? They built a circumstantial case, like just like in the Lindbergh case, and what they're going to have to do in the Nancy Guthrie case. So they gave the jury prosecutors did a good job because they gave the jury what a strong circumstantial case often needs. They gave them motive, means, and a timeline. And we're going to have to see that in Nancy Guthrie. So let's start with motive in this case. I'll take this down for now. Yes, so thanks. Were there charges for the baby? Yes. And I will get into all that. In fact, I find this case very interesting on how it was charged and how you only have 2 victims, right? Yet there were 4 M convictions. So how does that happen? So we're going to get into that. But first, I want to get into, instead of being sidetracked, I want to get into how prosecutors proved this case. And again, we're going to have to do it with Nancy Guthrie. Hopefully, we will be talking about that at some point. So starting with motive, prosecutors argued that Taylor did not want Jade to have the baby, and they introduced text messages that showed Taylor trying to convince Jade to abort the pregnancy. And they also called 2 of Taylor's former girlfriends as witnesses. These women testified that Taylor had previously pressured them to obtain abortions or take abortion pills. So we're talking Taylor's former girlfriends here. Now, immediately, if you guys are tuned into watching law shows, right, you think, oh, prior bad acts. How did that come in? Now, I can already hear the defense objection. Prior bad acts. So what do these other women, prior girlfriends, have to do with whether Blaise Taylor murdered Jade Benning, right? So generally, as I mentioned, prosecutors cannot simply say he did something bad before, therefore he's a bad person and committed this crime. They can't do that. So that's called propensity reasoning. But evidence of other acts may sometimes be admitted, and I'm not sure if this would be admitted in Massachusetts, but they'd be admitted for a different relevant purpose under the applicable evidentiary rules of the state. So the purpose of motive, intent, plan, knowledge. So the exact basis depends on the judge's ruling and the evidence presented. Here, the prosecution's theory was specific that Taylor did not want to father the child, and according to the state, he first tried to persuade Jade to terminate the pregnancy, and she didn't. So they did allow that evidence in. Like I said, not all states would do that. So prosecutors argued that getting rid of her altogether became Taylor's final resort, right? The state alleged that Blaise Taylor covertly mixed a lethal dose of cocaine into Jade's pink lemonade during a date night. And there was a piece of evidence that must have been, oh, okay, wait a minute. I'm getting ahead of myself. So part of the evidence, I think, was that I thought was pretty devastating to the defense, right, is Jade made a final phone call to her very best friend. And during that call, Jade said that her drink tasted funny, because originally when I was reading about the case, I thought, geez, all that cocaine to actually kill someone, right, must have tasted funny. You'd have to be able to taste the cocaine in the pink lemonade, right? That somebody put something in it. But she called her best friend and she said, you know what? My drink tasted really funny, as if somebody put something in. And she was feeling kind of feeling funny at the time, not feeling right. And then after that phone call, she stopped responding. And again, that's part of the timeline that the prosecution used. So the prosecution said Taylor wanted the pregnancy terminated. Jade did not terminate it. And Jade says that her drink tastes funny, all part of the timeline, right? She suspects something's in it. She becomes critically ill. Then they go to the hospital. They try to save the baby. Ivy dies. Jade ultimately dies, a part of the timeline. And Blaise Taylor, the defendant, initially told 911 that Jade is having an allergic reaction, right? So the prosecution's question was simple. Was this a medical emergency, or was it a poisoning staged to look like it was an emergency, right? Now, what does the defense do with all that? Because I like to talk about the defense side of things as well. So, excuse me, and losing my voice again. And remember, this is happening after the fact, after we already know the verdict. So the defense, I think, did its best. And in any circumstantial case, they did what they had to do. So the burden, remember, always remains on the state. It always remains on the government. The defense needed to create reasonable doubt. When the government has to prove their case beyond a reasonable doubt, the defense must poke holes in it. So their strategy was to muddy the waters, right? So first, they offered an alternative explanation for the cocaine in the drink. They introduced evidence of Jade's prior drug use, including messages discussing marijuana and mushrooms. And their argument was essentially perhaps Jade ingested the drugs herself, and this was sadly an accidental overdose. But I actually see a problem with that argument. So, evidence that somebody previously used marijuana or cocaine or mushrooms does not automatically establish that she voluntarily consumed a lethal amount of cocaine on that particular night, right? Especially while pregnant, and we know that she wanted to have the baby. So that really didn't make sense, and the jury didn't buy that theory, obviously. So the defense also attacked the integrity of the crime scene, which I think was a good way to attack. So what happened in this case is Jade's friends had cleaned or somehow disturbed the area before the police fully processed it. So that creates an obvious defense argument. It's one of the defense attorney's favorite things to do. Was key evidence lost? What was moved in particular? Was something contaminated when they did that? So they would ultimately argue, can you trust the physical evidence here? So this is exactly how a defense attorney attacks a circumstantial case. If we, again, going back to Nancy Guthrie, that will be one of the things that you'll see attacked if we ever get there, right? The crime scene. And outside, of course, you had the two investigations. You had the sheriff's investigation and you have the FBI investigation. So did the sheriff's department screw it up ahead of time? Defense attorney will look at that as well. So, I will say, though, you don't necessarily have to knock down the entire prosecution theory. If you're the defense attorney, only little bits here and there, and sometimes that's enough to do it. So you just need to create enough uncertainty in enough places that jurors will begin to hesitate. But then, going back to Blaise Taylor, the defense, and this really stinks for them, the defense had a problem with its own expert. I haven't really seen this before. So the toxicologist called by the defense was cross-examined about a case blank. So meaning a case blank is essentially a control sample that experts use. It's supposed to be clean and helps identify whether contamination may have occurred in the testing process. So I can't believe this. When I read it, I was like, oh my God, I can't believe it. But fentanyl was detected in the control sample. And that's a big problem, right? If a control sample that should be clean tests positive for a drug, what does that tell you about the testing process? And the defense, they're hoping that their toxicologists would somehow undermine the state's forensic case, but instead, that testimony appears to have raised serious questions about the expert's own analysis. So jurors probably just, shook their heads and raised their eyebrows and sat back and tuned out the rest of the defense case. That's what I think most juries would do. So at the time, the courtroom got very tense, and the judge directly interviewed the toxicologist during the toxicologist's testimony. and ordered the witness to answer the prosecution's questions when they were having a heated exchange. So some courtroom observers in the case criticized the judge's intervention and questioned whether the judge appeared biased somehow against the defense. And I think I talked about this last week when we were talking about Karen Reed. Judges have to appear neutral. They can't appear that they're, siding with one side or another. So we talked about that in the last Karen Reed hearing, where the judge made a joke about Alan Jackson and wanting the publicity, right? And I mentioned that, some people didn't think it was a big deal, but judges always do have to be careful. But something that I always tell people about trials is jurors, and I was a juror once, believe it or not, jurors watch everything, okay? They watch the lawyers, the defendant, they watch the judges and the witnesses. They notice when a judge becomes frustrated with one side or the other, and perception really is a big deal in a courtroom. If jurors already believe an expert is being evasive, a public reprimand from the judge may further damage that witness's credibility and, of course, further damage the defense's credibility. So in that case, I was actually very surprised. So now we're on to why were there 4M convictions for 2 victims? And now I'm going to answer the question about the charges for the baby. So I did eventually get to it. I got to put my law professor hat on for this one, though. So Blaise Taylor was convicted on 4M counts with 2 victims. Jade Benning was one, and then her unborn daughter Ivy was another. So how do we get 4M verdicts? So this is where I would say criminal procedure and substantive criminal law intersect. First, we're dealing with Tennessee law, and they permitted prosecutors to treat Jade and her unborn child as separate homicide victims. And again, we're looking at state law, and law differs, it varies from state to state. So Tennessee's homicide statutes include an unborn child within the statutory definition used for homicide offenses. So legally, prosecutors alleged 2 deaths because we had 2 victims, the mother and the unborn baby. But still, it doesn't explain the 4 murder counts. So the second piece of this is alternative legal theories. Prosecutors frequently, and I did this as well, we frequently charge more than one legal theory arising from the same criminal act. So think of it as a legal fallback system, all right? So, when you're preparing for a case early on, you're talking about it with your colleagues at the DA's office and with the police, where you're thinking, well, the jury may reject one theory, but accept another. And that's exactly what happened here. So for Jade's death, and this is the mother, the jury did not convict Taylor of first-degree premeditated M. Instead, jurors found him guilty of the lesser included offense of second-degree M. And that's significant. The jury apparently was not convinced beyond a reasonable doubt of every element necessary for first-degree premeditated murder, M, as to Jade, even though they came back so quickly in 2 hours. But, all right, they did believe the evidence established second-degree M. Now, for Ivy's death, this is where it's really interesting to me. The jury convicted Taylor of first-degree premeditated M, and that's for the unborn baby. So we already have 2 different verdicts under the premeditation or intentional homicide framework. But here's why we have 4 altogether. Prosecutors also charged felony murder. So what does that mean? The second piece is, of course, that felony murder is the alternative legal theory that I was talking about. And in this case, so if I can explain felony murder, so first degree for Jade, we talked about that. And felony murder means that we have the M was, why am I losing my track of train of thought here? But the M was happened while they in the commission of a felony. And what was that felony? The felony was the putting the cocaine in the lemonade, right? So that was considered felony M. So that's why we had 4 altogether. And again, the jury accepted so more than one legal pathway to criminal liability for each death. And the 2-hour verdict. So it's interesting because the jury deliberated for 2 hours, and I found that was amazing for a poisoning case. So again, we go back to circumstantial evidence. The prosecution put it together, and it doesn't. Circumstantial evidence is simply a form of proof, right? So, for example, if I walk into this is what I think the judges will tell jurors, and I love this one. They say to explain circumstantial evidence is just like if I walk into a courtroom soaking wet, carrying a dripping umbrella, right? You didn't see me standing in the rain, but you can reasonably infer that it was raining. So that's circumstantial evidence. And that's how the prosecution built the case. A poisoning case is very often built that way. There may not be any eyewitnesses standing there watching Taylor put the cocaine in the lemonade. So the jury has to examine the totality of the circumstances. And then they have to look at what is the reasonable inference drawn from all the evidence. So, jurors came back in 2 hours guilty. So he will be ultimately sentenced. And here's another thing that was different that I forgot to add in this, that is that in this particular state of Tennessee, so the jurors also considered sentencing. So the jury rejected life without parole for Blaise Taylor. And I thought this is where the case took another interesting turn. So the prosecutors, of course, sought life without the possibility of parole, but the jury recommended life with the possibility of parole. And I thought that was interesting because they did it, yet convicted Taylor so quickly. They accepted the prosecution's M theories, but they didn't give the prosecution everything they wanted in sentencing. And that's an important another lesson to learn about juries. A jury can believe overwhelmingly that a defendant is guilty and still separate the guilt from the punishment. So in this case, the defense reportedly, they focused on the legal time limitations surrounding the victim impact evidence. So the defense was able to get up and talk about sentencing and asked the jury not to sentence him for life without the possibility of parole. And the jury did give the defense a little bit of leeway there. So again, I would say emotion alone does not necessarily satisfy every legal requirement for a particular sentencing outcome. So the jury left a path for parole, and Blaise Taylor will be sentenced formally on September 9th. So I'd say in closing, right, what do all these cases have in common? And I go back to 1932 Lindbergh, our Nancy Guthrie continuing investigation, and then Blaise Taylor is, we're talking legally, they boiled down to one thing, right? And that would be circumstantial evidence and how we determine what is true, when no one directly witnessed the central act. So we don't have a direct witness as to any of these crimes. And remember, 200 people falsely confessed to kidnapping in the Lindbergh baby case. And the FBI is now sorting through ransom demands in the Nancy Guthrie investigation. They have to figure out which is real and what evidence they can ultimately use at trial. And they have to dot the I's and cross the T's, right? So, which information is authentic? And of course, in Nashville, we had no eyewitnesses that saw Blaise Taylor put the cocaine into Jade Benning's pink lemonade. So prosecutors reconstructed the story. So this is what investigators and the prosecution must do. We must constantly be testing statements, coordinating evidence, and figuring out what people know. And ultimately, we'll be asking a jury to separate that what's real from the noise out there. So, yes, I ultimately hope that this Nancy Guthrie case breaks wide open, and I will be following all developments. And again, I will have somebody on as to the conspiracy theories in the Lindbergh case because I find that very interesting as well. Well, I think that's about it for today on Lunchtime Law. Thank you very much for watching, and I'll be sure to subscribe. And if you liked it, press the like button and tell all your friends about it because I am going to be doing this thing every day. And let me tell you, it's not that easy to get ready for and prepare for because as a lawyer and a law professor, I always want to be as prepared as possible when I speak on certain cases. So, and I don't know what I'm going to talk about yet tomorrow. I'm going to check the headlines and come back with something that I find very interesting and something that I can teach you guys about. So we're going to translate the law again for you tomorrow, right here on Lunchtime Law with Margaret McLean. So again, thanks for tuning in. And